Good morning. My name is Bobby Link. I'm here on behalf of David A. Gallo and Associates. This is a webinar called Commercial Leases and COVID-19. This is your update on the commercial eviction moratorium and also some of the tenant protections that are available and the defenses that are starting to be litigated at the trial court level. I thought it was important to do this webinar now because while there hasn't been a flooding of eviction cases in the courts that are really moving through the pipeline, we are starting to see some decisions coming back from the trial courts addressing important defenses like frustration and purpose and possibility, the application of the executive orders from Governor Cuomo, and some of these other things. So that's what we're going to be talking about for the next hour. I would ask you that if you're on the line, please keep your microphone muted so that we don't have that background noise. If you have a question, I'll do my best to check through the chat function throughout the program just to make sure we incorporate that through the program to the best of our ability. If not, save the question for the end of the program where you can either ask your question through the chat or just ask us directly via video or phone, however you're joining us, and we'll do our best to give you enough time to get those questions out and make sure you get a response. I'm going to share the screen here. Okay, again, commercial leases and COVID-19. My name is Robert Link. You can email me at blink@msgrb.com. If you have any questions about the program, feel free to just contact me. And we offer 20-minute free consultations for small businesses who have been affected by the pandemic or landlords who are trying to strategize about preparing their property for 2021 and beyond. That's my direct phone number, 718-269-7607. Just a little bit about me. I'm a civil litigation attorney. My background is in foreclosures, evictions, and bankruptcies. Generally speaking, I'm a courtroom attorney. I'm used to going to court, handling discovery, handling trials and evidentiary hearings. But for the last 8 to 10 months, predominantly, David and I have been focused on working with landlords, working with tenants to get through this COVID-19 pandemic, specifically renegotiating the terms of the lease in a way that is palatable for both the landlord, who oftentimes has to pay expenses associated with the property, it has to pay taxes in some situations depending on the terms of the lease, and the tenant, which has been in some cases completely shut down, in other cases partially shut down. So David, what do you want to tell us about yourself?
Well, I have Bobby's background and my background are pretty similar, only I've been doing it for a little longer.
A little bit, David.
As Bobby said, we've been focusing on commercial leases, especially since the pandemic, trying to help both the landlord and the tenant out. And I'm going to also put Daniel Angelillo on the spot. He's not part of the program, but he is a retired Justice of the Appellate Division, Second Department, who's of counsel to the firm. Glad he's here today, and I'm sure he'll share any information or any opinions he may have on some of the things that we talk about.
Great. And then also on the call, we have Jessica Calra, who is a senior associate at the firm, and her focus, her emphasis is real estate transactional work, but she's here to answer any questions you might have. Jessica, anything you want to say about yourself?
Yeah, I don't handle the litigation end, but I handle the REO, or closings, originations, and which is a different department of the firm. But obviously, a lot of our work is, in essence, getting affected by these evictions, these landlord-tenant issues. A lot of our matters are also, as being REO, are being sold as is, and we're encountering many buyers now, facing situations of how to deal with evictions once they purchase these as is properties.
Okay, all right. So let's move on. Here's what's going on right now. There is a commercial eviction moratorium but it is not applying to holdovers. A holdover is when the lease term is up and the lease has been terminated. A non-payment eviction is when you're not paying the rent and the landlord is suing for the back rent and to terminate the lease for non-compliance. If you're a non-payment, there is a moratorium currently in effect pursuant to Executive Order 20281, and that is extended through the end of January 31. We don't know if it's going to be extended beyond that. We don't know if the executive order or the moratorium is going to be made more broad, particularly in light of some of the closures in the restaurant industry and some other industries. Governor Cuomo has made some references to perhaps doing something for for commercial tenants. But right now, commercial tenants haven't received any assistance really whatsoever from the state government. Particularly as far as these defenses go, if you're ignoring, some of these early executive orders and legislation. We're going to look at some legislation a little later in the program that is out there, some proposals that will be discussed in committees. But right now, the relief that has been afforded to residential tenants hasn't been afforded to commercial tenants. What's there? We'll review that right now. There's Executive Order 202.28. That was the initial executive order that provided a 90-day blanket moratorium on holdovers and non-payments. So you shouldn't have received a holdover eviction or a non-payment eviction from March 17th, 2020, when the pandemic began, through April, May, June 17th. There should not have been any evictions commenced during that period of time. There's a question about whether or not you could have sent notices during that time. That's going to be notices to terminate your lease in order to, as a prerequisite to bringing a holdover eviction. This is something that's going to be settled in the courts over the next months and perhaps years. We don't have an answer to that question today, but that's something to keep in mind. So there are all of these resident executive orders out there. You want to be familiar with them. Right now, there are pending cases. They are limited to the holdovers and the cases that were brought before March 17th, and then some other issues related to failure to comply with legal requirements, emergency repair issues that are being brought in the housing court. But generally, it's just those holdovers that are moving forward, and they're moving forward slowly. David, I want to incorporate you in the conversation here. What are you seeing as far as these holdover cases moving forward right now?
Well, we've started to commence holdover proceedings in Nassau, Suffolk, and the boroughs. And what I'm finding is that the court is accepting the petitions, but they are administratively adjourning them, for instance, into the future. For instance, we commenced a holdover in Nassau County back in October, and they gave us a date in March. I had a client that was a tenant. Holdover was commenced in July and was administratively adjourned into January, and that was Nassau. In fact, I went online to make sure the case was on. It was supposed to be on January 6th. I called the court and I said, I represent the tenant. I'm coming in on this, and they said, no, you should have gotten a notice of adjournment. I didn't. I'm glad I called, saved me the trip going in. But it got administratively adjourned to June 6th. So here's a case that was started in July of 2020, gets administratively adjourned twice, almost a year out. And who knows what's going to happen in June. Same thing is happening in the boroughs. You had cases that were, and this is just the holdovers. You had cases, perhaps in each borough, they had calendared 400 or 500 cases a day that have just stopped. And now, you also have, during the moratorium, and you also have pending cases that had adjournments during the moratorium. I don't know how they're ever going to catch up, and also allow for starting new cases. But that's really what you're dealing with, which is why it's a landlord and a tenant. They should really try to work this out on their own, and both be a little understanding what the other is going through. Because if you're going to rely on the courts, it's going to take a very, very long time.
I would say too, is particularly, David, if you're a landlord and you have a tenant that's otherwise been an outstanding tenant and has paid the rent timely and has been there for a good period of time, you know, if you're pursuing eviction, you're going to have to find another tenant in this landscape. And, you know, who knows if you're going to be able to get the same threshold of rent. You know, so you got to think about all these things. What's the end game and how long it's going to take to get where you want to go.
And is the demand going to be there for the space? I mean, we're already seeing, if we've learned anything in this pandemic, office space, you know, you don't need as much as you had. People can work from home and work from home productively. You know, restaurants, some of these restaurants, you know, landlord takes a position, either you pay me or you're out. Well, what are you going to do with the space? You know, try to work with your tenant, you know, because your chances are the space is probably adapted for a restaurant or food service use, and you're certainly probably not going to get someone in there very quickly, nor at the rent that your tenant was paying. So, you know, I find that a lot of landlords are, at least some that I represent, are all ears. They you know, they want to keep their tenants. They do want to get some income in, and they're willing to work with their tenants.
And if you're a landlord who is going to go forward with the eviction, you want to make sure you're reviewing all of these executive orders, all of the administrative orders, to make sure you are 100% in compliance with the letter of the law, providing any kind of notices that were required. We'll talk about that in a little bit more detail.
And the only other thing I'd like to add, since we brought it up, or I brought it up, is that if you are working something out with your landlord and or tenant, be careful what you work out, because, you know, anything you do now, you're doing with your eyes wide open. You're doing it during the pandemic. So if you bind yourself to an obligation that subsequently turns out to have not been a good decision, you know, I would think the courts are going to look at it differently than if you made this decision before the pandemic. You know, before the pandemic, who knew this was going to happen? Now you're making decisions knowing what the situation is, and knowing about the pandemic, knowing that there could be a recurrence. You know, so you have to be very careful that what you do, if you decide you're going to bind yourself today to a decision, make sure that you at least leave room for flexibility in the future. That I'm representing one tenant right now where I'm trying to work out something for the rent arrears through the end of December, but I don't want to talk about going forward yet, because we don't know what's going to happen going forward. We have an idea, but I'm certainly not going to put my legal advice on the line and advise someone where I don't know definitively what the situation is going to be in May, June, or even September or October. So you kind of have to deal with. I'm trying to use this opportunity with the tenants that I have to work out something that works for them for the year of through December 2020. You know, what were you able to open up? Did you do some business? What would be a fair amount to offer the landlord? Would the landlord accept it?
Right. I think that's an important point, that the conversations and ultimately any settlement that you come up with right now could prejudice, you know, your small business, from utilizing defenses somewhere further down the line. So that's why it's important to consult with an attorney about these important decisions. So I briefly want to talk about the residential moratorium because there was a lot of news about that, and the legislature marched into session. Actually, they reviewed this plan for the new moratorium, the COVID-19 Emergency Eviction Foreclosure Prevention Act. They released this plan on Christmas Eve, and they kind of let it out there and circulated it among the members in the majority in the legislature. And then the following Monday enacted this proposal into law. So that's how quickly things can happen in the New York State legislature, because there are a supermajority of Democrats in both chambers and a Democratic governor, which you wouldn't even need because, again, you got a supermajority. So at a drop of a hat, at a moment's notice, there could be a new law in Albany, and you're really only talking about a few days from when the idea is proposed, moves the bill through committee, ends up on the floor in both chambers, and gets voted through. So that's important to kind of understand on both ends. If you're a landlord or a tenant, know that the laws could change hypothetically. Lawmakers went into session this week and are starting to meet in committee. So there's various proposals. We're going to talk about them. COVID-19 Emergency Eviction Act applied to residential tenants. It's a full-scale moratorium for 60 days for holdovers and non-payments if there is an election by the tenant to complete a hardship declaration form and submit it to the landlord or submit it to the court. They can get a further stay through May 1, 2021. We'll see whether or not that is constitutional or not. I'm sure several landlords might be interested in challenging under the takings clause or under the contracts clause. However, that was previously done, and the federal courts have thus far said that in order to protect public health, they've been able to delay these eviction and foreclosure proceedings. So here you have DW from Arthur. She's sitting at the other end of the gate watching the other kids play. She's the commercial tenant, and so far the benefits have mostly gone to the residential tenants. We'll see what's in store for the commercial tenants as we move on. So here are the defenses that the commercial tenants have at their disposal right now. Again, you got the executive orders and the administrative orders. So these are laws that are enforced by the governor of the state of New York, Andrew Cuomo, is released and just declared them to be laws using his police power to maintain the health and safety of the citizens of the state of New York. In addition, you have the Office of Court Administration, which crafts these administrative orders, and they're attempting to comply with the governor's wishes or the legislature's laws that have been passed. So right now you have administrative order, for example, 12720, which was superseded by administrative order 60A20, which required commercial evictions to include an attorney affirmation. They eventually got rid of that requirement because it was a little bit cumbersome for the landlord attorneys. It's not clear whether or not the cases that were brought before August 20, 2020, when they changed their mind about that requirement, had to comply. I would assume the courts are going to hold that they did have to comply with that requirement. It was, I think, between June 20th or June 18th, 2020 and August 20, 2020, that the attorney affirmation had to go out with your holdover eviction papers. And then there's the current executive order through January 31st that precludes a landlord from filing a holdover action against a commercial tenant. It's also RPAPL 733 requires the petition in a summary holdover proceeding to be returnable at least 10, no more than 17 days after the tenant was served with the petition and notice of petition. We'll talk about that in more detail. In possibility of performance, we're going to talk about that a lot. That's essentially saying that the purpose under the lease could not be realized because of the pandemic or an act of God, and as a consequence, that provision of the lease is no longer enforceable, whether it's the payment of the rent or whatnot. And then also there's a tenant harassment law. I'll talk about that a little bit right now. The New York City, this is applying only to New York City properties. New York City Administrative Code, Section 22902. It's essentially saying if there were improper acts by the landlord during the course of the pandemic to threaten or intimidate the tenant on vacating the property when they didn't have a legal right to force the tenant to vacate the property, well, then they can be civilly liable for damages, and courts can issue injunctive relief and other kinds of remedial relief. So if you're in New York City and you might have a situation like that, the statute provides, I think it's 11 enumerated examples of where the landlord is, turning off the lights, or not making repairs, or sending threatening emails. That's the kind of behavior bringing frivolous lawsuits that you might want to interpose a tenant harassment counterclaim in your eviction. So that's something to kind of keep in mind. Let's talk. Okay, also Administrative Order 12720 and Administrative Order 6820. We talked about this briefly. These are guidelines that were promulgated by the Office of Court Administration. It says in your eviction, your petition, and your notice of petition have to include exhibits. And that exhibit includes, if you're in New York City, a phone number and a website for you to contact an attorney and be familiar with your rights during the COVID-19 pandemic. The landlord has to include that. And again, in that small window of time between June 20th and or June 16th and August 20th, you also had to do an attorney affirmation that was saying, in effect, that the landlord complied with all the COVID-19 prerequisites. The landlords eventually complained about that, and the Office of Court Administration rescinded the requirement. But the cases that were, it was a bit cumbersome. Essentially, what they were doing was making the landlord attorneys testify to the fact that the landlords had complied with the letter of the law under the Coronavirus Relief Act passed by Congress, under all the executive orders and all the administrative orders. And the landlord's attorneys responded, well, we can't do that. We don't know exactly what our tenants did, and it's too cumbersome to comply. So the Administrative Order 6820 rescinded that requirement. If the NewYorkCourts.gov has some great information, if you want to review all those, they're all sitting there. You can review them one by one, but again, best to work with an attorney to be prepared, particularly if you're a landlord with all of those prerequisites to bringing your lawsuit. You want to make sure you dot every I and cross every T. RPAPL 733. I think this is interesting. David, I'm interested in your thoughts on this. The law says that if you're bringing a holdover action, you have to serve the petition and notice of petition at least 10 days, but no more than 17 days before that holdover action is scheduled to be heard in the housing court. So you have this small window of time, 7 days, when you have to give your commercial tenant notice to appear in court and oppose the eviction. Now, here's the problem. In the current context, these housing court petitions are being submitted with no date, or they're being submitted with a date and they're being administratively adjourned. So if it's being submitted with no date, the court is, I was looking at one eviction that I saw, the court puts a stamp on there that essentially says, we'll let you know when this case is going to be on the calendar, but it's not going to be on the calendar immediately, because they didn't have full staff handling the administration of these cases and these holdovers. They wanted to allow the landlord attorneys to move forward. They weren't really scheduling it in the normal fashion. So these petitions were not served at least 10 days and no more than 17 days. David, do you think this is a viable defense for some of the commercial tenants out there to interpose? And do you think some of the evictions that were brought over the summer and were either didn't include a date or were administratively adjourned, are those landlords going to have difficulty obtaining a judgment of possession?
So I know you and I have a little difference of opinion on this. In my opinion, if you have two choices, usually on a holdover proceeding, the landlord inserts the date that the case is returnable on. If during this period the landlord inserted a date that the court looked at and said, well, that's not happening, and administratively adjourns it to a subsequent date that's convenient for the court, I don't think the landlord should be penalized for that. The landlord did what the landlord could do. They served it at least 10, not more than 17 days. They put a hearing date in that complied with that, and the court on its own said, well, we can't accommodate that date because of what's happening right now. Therefore, we're putting it off, as I said earlier, 3, 4, 5 months later. The landlord has no control over that. There was no prohibition in instituting a holdover proceeding. To me, that should not have an adverse consequence to the landlord. I know some landlords are leaving the date blank because they know the court's not going to accept the date that they put in there. So instead of putting a date that's compliant with 733, they leave it blank, let the court fill it in. The 733 is supposed to be strictly construed. That's not complying with it. It seems like a practical thing to do, but it's not what the statute says. I think if you leave the date blank, I still think, and the court puts a date in that's 4 or 5 months out, I still think the landlord's going to be okay. I feel less confident about that than I do about where the landlord does exactly what the statute says. But the court is putting in a date that is convenient for the court, and it's accepting the petition that way. I think the judges are going to say that if it isn't if it is a defense that it wasn't 733 wasn't complied with, I think the judges are going to say, well, the court put in a date because of this pandemic. They couldn't put in a date that was compliant with 733, and the court put in a date that would work for the court. Therefore, we're not going to penalize the landlord. That's my opinion.
So, David, why, if I'm advising the landlord, wouldn't I recommend that you serve the petition and the notice of petition initially with your, maybe your stamp or your date, and then when you get the adjourn date, or if the court finally selects a first date, then you serve it again in that 10 to 17 day time frame? Wouldn't that be the belt and suspenders way of complying with 733?
Well, you're talking about buying a new index number or just reserving?
No, I've just reserved the same petition and notice of petition, and then file the affidavit of service with the court that shows I complied with the law. I gave notice 10 or 17 days. I mean, ultimately, what the law is trying to ensure happens is due process. So is the tenant being apprised of the date that they need to be in court? And I don't know that they're necessarily being apprised of what date they're being told to go back into court if the date is the wrong date or the date isn't provided at all. How are they supposed to know what date to go to court?
If the date is the date that the landlord selects and is compliant with 733, and the tenant goes to court that day and finds out that the case is not on because the court did not respect that date that the landlord put in there, but the court administratively adjourned it, I think due process is served. We served, we did what we were supposed to do, and the court on its own initiative chose to administratively adjourn it. The case was on and was not going to get on the court's calendar. They adjourned it to 3 or 4 months out. The tenant would be advised of that. You know.
Well, that's if the tenant is advised of that. I know of some circumstances where the tenant is not advised of the adjourn date. And what has to happen is the tenant or the tenant's attorney has to, you know, look at it, you know, make various phone calls, try to get a judge or court staff to return a message or respond to an email. And it does get a bit confusing. But again, I mean, this is something, you know, that this conversation that David and I are having is something that's going to play out in trial courts, in housing courts, and in some circumstances, I guess, in Supreme Court, we have Yellowstone injunctions, and all these other proceedings.
As well as in the appellate courts. And since we have a retired justice with us, Judge, what do you think? If you have an opinion.
Judge, you've heard the arguments. Are you ready to render a decision?
Well, I'd like to begin by, first of all, can you hear me all right?
Yeah, we can hear you great.
Oh, great. And thanks for the invite. I'm sorry that I don't have a tie on today. I apologize for that. But anyway, I'm familiar with how Westchester County operates. That's my home base. And of course, we have town and village courts and some city courts, but there are quite a few town and village courts. And I know from experience that that in the town courts, you can actually, like for example, in Harrison, let's say you had a landlord-tenant petition in the town of Harrison, you could pick up the phone, call the clerk, and discuss with the clerk a date that should be inserted in the petition, because, for example, we don't sit every day of the week in the town and village courts. We might have 1 day or 2 days a week that are set aside, and that 1 or 2 days may be just for criminal, or maybe a day for civil cases. So you select a date that's convenient with the court. You select the date that the court is telling you to select. And this way, I think it's just a piece of practical advice if you're dealing with the courts in Westchester County. I'm not sure if this would work out in Long Island or New York City because of the volume of cases, but I know with the smaller courts, you can pick up the phone, talk to them, and select the date. And this way, then you serve based on the date that the court gave you to insert in the petition. I don't know if that helps at all, but I from a practical side, it might resolve this issue, and you don't even have to deal with this possible defense being raised if you're you know, the landlord.
I think that's good advice, Judge.
Let me ask you then, if the date the court selects when they call in is not compliant with 733, do you think that would be a viable defense?
Well, you're going to select the date that the court gives you, and then you serve based on that date. So hopefully you'll serve it in relation to the 10 or 17 days that work around the date that the court has given you.
I see.
Right. And I think maybe one of the issues, I want to move on, but I mean, I think one of the issues might be in New York City, it's not the town of Harrison or even the city of White Plains. You know, it might not be as easy to just kind of pick up the phone.
Yeah, and I preface that. I agree with you, Robert.
Sure.
I agree with you 100%. But if you do have a case in the suburbs up in Westchester County, that might be a way of dealing with it.
All right, so let's move on to you know, something that there's been a lot of activity on as far as defenses interposed. That's the frustration of purpose and impossibility defense. And those terms are kind of used interchangeably. They're technically separate defenses, but you see even the courts kind of use them interchangeably. What it's essentially saying is that, you know, the purpose of the lease, I rented a restaurant to operate at this premises, and Governor Cuomo's executive order says I can't operate a restaurant, or I can't have patrons inside of my restaurant. And the question that is the courts are now faced with is, you know, is the restaurant or retail tenant or whatever the case may be, the gym, liable for the rent during the period where they couldn't perform the purpose of the lease. David, what can you tell us about the impossibility defense?
Well, so impossibility, you're basically saying that there's you have to, as the tenant, you have to establish that there was an unexpected intervening event that occurred, and that the contract did assume that that would not happen. Otherwise, it would have perhaps dealt with it. And this event made performance impossible. So if something like that occurs, how do you expect, especially when there is a government shutdown of your business, how do you expect me to perform under the terms of my contract, which is a restaurant where I take people in to sit down and serve food, when I'm being told I can't do that? I think it's impossibility of performance, frustration of purpose, which, as you said, they're interchanged. They're a little bit different, but it's basically the same outcome. It's it's an event that happens that the contract didn't assume was going to happen, and it wasn't either party's fault. So, in my opinion, if this pandemic isn't classic for a frustration of purpose or an impossibility of performance defense, I don't know what is.
So you have your unforeseeable event, which could be COVID-19, and these administrative orders shutting down various industries, and performance has been rendered impossible. I mean, that's your fact that you have to social distance. That's the fact that the industry has been shut down. That's the fact that you can't have patrons in your store. Do I have that understanding correctly?
Yes. There's a second part to it, but yes, for as far as we've gone, yes.
And this is related to the concept of force majeure. In some commercial leases, you're going to see what's called a force majeure provision, which says if there is an act of God, if frogs fall from the sky, if there is hurricane or something to that effect that wipes out the premises, you're not liable. How does the force majeure concept interact with impossibility of contract?
Well, the force majeure has to be a specific event. It has to clearly be delineated in the force majeure clause that the event that you're addressing. New York doesn't take kindly to generally stated force majeure clauses. If you just say if some unexpected event happens and it frustrates the purpose of the contract, that the appellate courts have told us that's not going to work. The force majeure clause has to be very specific to the event that's occurring, which is frustrating the purpose of the contract, which is what you're looking to be relieved of your liability or your obligation.
All right, so let's look at some examples. You got the gap case. There's like I said, there's about half a dozen, 10 cases at the trial court level that are starting to grapple with these issues. They've never had to really discuss it before because there has never been one of these unforeseeable events. There's been pandemics. We had Ebola and the bird flu and whatnot over the course of years, but nothing on the scale of what we're talking about in COVID-19. So in the Gap Inc. v. 170 Broadway, which was actually a case where the Gap brought a lawsuit to prevent 170 Broadway from terminating the lease. The judge, and in that case, the Gap interposed the defense of impossibility of performance in response to 170 Broadway, the landlord saying, well, in the interim, you need to pay the full rent while you're enjoining us from terminating the lease. And what the judge in that case said is specifically, COVID-19 could not have been foreseen or guarded against. The judge said the pandemic destroyed the means of performance of the contract, referring to the government shutdowns of the retail industry, and COVID-19 generally making it harder to operate a retail establishment. And what the judge also said in that case is that the tenant states a viable claim. Importantly, the judge did not declare that the Gap didn't have to pay their rent. The judge did not say that X amount of dollars was going to be abated from this portion to that portion. What the judge said is these are issues of fact. We need to really dig into the facts here, have discovery, have a trial, and determine to what extent the Gap was able to operate its business. And then presumably the next step is that the Gap's rent for the affected period would be abated accordingly. David, do you read the case the same way?
Yes, and the other part of the case is you might be asking yourself, gee, why was the Gap starting a lawsuit? You'd think the landlord would be going after the Gap. And the reason for this was that the landlord decided to take advantage of a clause in the lease saying if you're in default of the lease, we're going to terminate your lease. So they sent the Gap I think it was a 10-day notice to cure to go back into business again. Like you're supposed to be compliant with the lease, you're not, and therefore we're going to give you a 10-day period to cure this default. Thereafter, they would have served a notice of termination. So what the Gap did, which is the recommended course of action, is they went into court immediately to say we need a stay of the landlord terminating our lease because we can't, whatever they said, we can't cure. There's a pandemic going on. And in this case, the court granted what's called a Yellowstone injunction. The first case was back in, I think, in the 70s or the 80s in Queens, in I think it was Forest Hills or Rego Park on Yellowstone Boulevard. And the court said, I'm going to grant the Yellowstone injunction because if I don't grant the Yellowstone injunction and the cure period expires, and in this case, I think the cure period did expire, and the courts are pretty much general consensus now is that the cure period can expire. You just can't let the termination occur. So you might have a 10-day notice to cure, that expires, and then the landlord serves a 5-day notice of termination. Well, before that notice of termination becomes effective, you have to get what's known as this Yellowstone injunction to stay the landlord from terminating the lease. Because if you allow the lease to terminate, the court says, well, there's nothing more we can do. You let this lease terminate. You may have had viable defenses to why it shouldn't terminate, but you let it terminate. So it was very important for the Gap to go into court and seek a declaration of its rights, saying under this pandemic, we can't pay our rent. The landlord's trying to terminate our lease. We don't want our lease terminated. Please, judge, grant a stay of termination. And in this instance, the judge granted the stay, so the lease couldn't be terminated. But as Bobby just said, the judge didn't say, well, I'm not, we need more discovery. I'm not just going to abate all your rent. Maybe some of it should be abated. Maybe some of it shouldn't be abated. The Gap, you do business, mail away business. Maybe you could still continue to generate some income. And if that's the case, then maybe we should abate a portion of the rent. Not all of it, because you did what you could in order to bring revenue in, even though you couldn't bring people in through the store, which is where this is very important and with restaurants, because restaurants are capable of offering takeout, which the courts, which the governor is has allowed since I don't remember the last executive order, but so if you're a restaurant or you're a dance studio or you're someone else that is able to conduct business, maybe not the way you were doing it, but in a way that can bring in some income, I think that's important, and that's what the discovery is all about, requiring the parties to exchange discovery, to say, you know, you were a restaurant. Did you just shut your doors and sit on your laurels until this whole thing was over, when you could have perhaps improvised and brought in some income, and maybe you brought in 30% of the income that you otherwise would have? Well, maybe then I'm going to abate 70% of the rent, but you do owe the landlord 30%.
I mean, that's why it's so important, David. That's why it's so important that if you know, it's for us representing landlords or representing tenants to make a good faith effort at the minimum to reach out to the other side and try to work out a deal that works for both parties. And that can't always happen. But at the end of the day, you're going to be waiting a long time for a random person in a robe to make a judgment for you if you're not able to come up with a mutually agreeable resolution with your landlord or with your tenant. So to the extent you can discuss, you know, the percentage in which you're able to maintain your business operations. Listen, I can do this, I can do that. And if you can do it in good faith and you can do it in a way that works for both sides, you know, obviously we want you to do that. We're running a little bit long, and I want to give time for questions, but let's get through these next couple of cases on the impossibility doctrine. International Plaza Associates v. Amore Pacific v. Innisfree. This is a beauty supply store. This is one of the most tenant-friendly decisions I saw. It said a beauty supply store hampered by COVID-19 and was affected by COVID-19, and performance was made at least in part impossible because they rely on customers to actually go in the store and test the product. And you can't really do that if there's 6 feet social distancing and the partial closures. The lease provision for COVID-19 protections could not have been negotiated. There's language in the decision that actually says this is not something that, you know, the parties could have foreseen. And the decision also said that the losses, this is kind of counters to, you know, another decision that's out there. The fact that the supply store couldn't operate and was losing money during the relevant period isn't just part of the ups and downs of business. This isn't the normal routine. Well, there was a downturn in the economy, and you know, you have to anticipate that that's going to happen. The judge specifically said in this case, this is not part of the ups and downs of the economy, and that was completely contrary to the most pro-landlord decision that we've seen, and that's 1140 Broadway v. Bold Food. And what the judge said in this case, this was not a retail tenant, this was not a restaurant, this was an office tenant, but the office tenant provided guidance and consultations with a restaurant, so it relied inherently on the restaurant industry in order to maintain operations, and the restaurant industry was shut down. So basically, they were shut down. The judge said that the restaurant industry might be able to exercise the impossibility defense, but the retail lease could still operate as a, you know, retail lease. You could still have people go into work, at least you know, for the most part. You still had your computers there. Just because there was a downturn in your area of business doesn't mean the rent should be abated. Court held this is not a case where the office lease space was destroyed or could no longer serve that function, and tenant was one step removed from the public health order. And so when I read this, and I read it in conjunction with the other case, what I'm seeing is you're going to have, depending on where you're standing and what judge you're assigned, at the whole gamut of decisions interpreting this doctrine, because this is a long-standing common law doctrine that has been with us, you know, from the beginning of our court system. But it's only really now starting to be utilized in this commercial landlord-tenant context, and we're going to see how this shakes out. David?
Yeah, the critical part of the decision here is, I'm quoting from the decision, here the lease was for office space in a building and the tenant's business was devastated by a pandemic. That does not fit into the narrow doctrine of frustration of purpose. Simply put, defendants could no longer afford the rent because restaurants no longer needed the management help that the tenant provides. It is critical to point out that the tenant merely provided restaurants with consulting services. In other words, the tenant was one step removed from the governor's public health orders relating to restaurants because their business assists restaurants. The court is unable to find that the doctrine of impossibility has any application here. That's a harsh decision. And what does that tell us? Maybe that negotiating leases going forward, and you're renting, especially for office spaces, particularly for office spaces, do you also have to put in the use for which you're going to make of that office? So, and then perhaps if that was in this particular lease, this judge would have found otherwise, saying, okay, well, the landlord knew that the use was going to be for office space for providing services to restaurants. Maybe the decision would have been a little different if that was in there, but it sounds like the general use clause in this lease was just for general office spaces and not for a particular use. So maybe going forward, tenants' attorneys have to think more clearly about that so that they're not one step removed. I would appeal this decision. Judge, what do you think? Yeah, put you on the spot. I don't know.
Let me just unmute. Actually, I was going to ask you, which court is this from?
This is
What's funny is all three of these decisions are from the New York State Supreme Court
in Manhattan.
in Manhattan,
Manhattan
the
Supreme Court.
New York County Supreme Court. Pardon me.
Oh, that's interesting.
So you have three different judges
Yeah.
who are seeing it different ways.
Would
Well,
any of these
if
cases
you
come out of the commercial part?
I know for a fact the judge on Bold Foods is not the commercial part. Yellowstone injunctions should, as a matter of civil court rules, be brought in the commercial part. So I would imagine, unless it was filed incorrectly, that the initial case was brought, the GAP case would have been brought in the commercial division.
Well, I think that I agree with David that the 1140 Broadway case is certainly a pro-landlord, or maybe you said that, David. I mean, Robert, this is a very pro-landlord decision. Very clearly it is. It appears to be worthy of an appeal, and be interesting to hear what the appellate division would, First Department would do with this type of ruling.
Judge, how long? I mean, my understanding is, I know at the Second Department, I mean, we're sometimes waiting 2 years to get a decision on an appeal.
Much faster in the First Department.
Right. So I mean, it could be literally years before we understand, or at least a year or two before we understand fully the implication of these legal doctrines in COVID-19 context.
Oh yeah.
Sure.
Well, some of them will go to the appellate term, I imagine. Not these particular cases, but I think some of them will go to the appellate term, right, David?
Yes. Anything
In the housing court.
anything that was instituted in the Supreme Court will go to the appellate division, and anything in the lower courts, the civil courts, the town courts, justice courts, they'll go to the appellate term with the possibility, I suppose, of going to the appellate division eventually, but probably.
All right. We only have a couple minutes left, and we want to leave plenty of time for questions. I just briefly wanted to talk about bankruptcy in the context of, you should be aware that subsection 5 of chapter 11 is a way to take advantage of chapter 11 of the bankruptcy code in a way that's cheaper, more efficient, and more friendly to the debtor. You're able to cram the plan over an objecting creditor. And under the CARES Act, the threshold, the debt limit threshold, was raised to $7.5 million from $2.7 million. In March, that law that portion of the law will sunset. It's unclear at this point whether or not it's going to be continued. That's something to watch. But you should also consider that option, subchapter 5 of chapter 11. If you're a small business and you're looking at, and maybe things are going well now, they're starting to kind of get back on track, but you need a way to deal with your debt, that bankruptcy courts might be a very attractive option. I also wanted to point out, since lawmakers are back in session in Albany, there's a handful of bills that could help out commercial tenants. Senate Bill 40 speaks to, I think it's a good bill, speaks directly to these impossibility defenses and says that COVID-19 was unforeseeable. You really only have to worry about the second element of the analysis about, to what extent were you shut down and could you not operate your business. 1129 requires landlords to mitigate damages when commercial tenants vacate. Generally, under a commercial lease, if you have a 10-year lease and you leave in year 8, you're still liable for the remaining 2 years, and the landlord has no obligation to go out and try to lease the premises as quickly as possible. This would change that. David, what do you think of this law and its impact in the industry?
Well, so you talked about,
and then let me correct myself. It's a bill. This is a proposal that has been introduced in the Senate. It's not necessarily headed towards passage, but again, this could quickly become law. All that has to happen is Andrea Stewart-Cousins and Assemblyman Carl Heastie need to get in a room and decide they want to make it a law, and it'll be done within a week.
So let's start with the latter question. If you're going to require, if you're going to require that the tenant, Bobby, what was the second part of the question? I was focused on the first part, and I just lost my train of thought.
What I'm saying is, you have a landlord.
Yeah, mitigation of damages, right.
Mitigation of damages, right.
So if you're going to require a landlord to mitigate damages, the question becomes, if you have 2 years left on your lease and a potential tenant is brought to you, but they want a 5-year lease and they want the rent to be half what you were collecting, is that something, if there's a requirement in mitigating damages, is that something that the landlord has to accept? Do they have to say, wait a minute, I don't, on the one side, the landlord goes, I don't want to tie my premises up for 5 years at a reduced rent like that. And the tenant that is going to be on the hook who vacated says, well, yes, you do, because the law says you have to mitigate my damages, your damages, ultimately what I have to pay. Therefore, I want you to take this new tenant in. And that, of course, would come out, and you say, how would they know that? It would come out in discovery, because the landlord perhaps didn't accept that new tenant. And the reason that they didn't accept the new tenant was because the term was too long, or whatever it might be. They may not be able to get them just to go in there for 2 years. So that's problematic. I don't know. I don't know what a court would do there. But what I was focusing on also was, when you. Well, does that answer your question, Bobby?
Yeah, I think that does. That definitely answers the question. I mean, it's at the end of the day, as attorneys, we're advising the landlord of, various possibilities about how this new law, if it's enacted, by the way, is going to be interpreted. So, I would say, on one hand, you don't want to handcuff yourself for the next 5 years at a severely reduced, monthly lease amount. But on the other hand, a court might, say that was part of your obligation to mitigate damages, at least for the remainder of the lease term. So, I mean, we'll see how that shakes out. At the minimum, I think if you're a landlord, you want to make sure that you're making all efforts to advertise and work with a real estate broker and keep those listings. And then you want to make sure that you save copies of those listings in case this becomes an issue later on. If you have a sign in your window, I think you want to take a picture of the sign in your window, and you want to put that in an envelope or an electronic file somewhere in case these issues come up later, if you're collecting on a judgment against the old tenant, or otherwise proceeding with some action to collect the debt.
Yeah, and I guess the other thing, the other proposed bill, which is what I got distracted with before, was having some legislation pass, giving the courts some guidance on how they're going to determine whether or not an abatement is appropriate or a deferral of rent is appropriate. Otherwise,
That's Senate Bill 40 that directly addresses the impossibility doctrine. And I think if that was adopted, you'd get cases, like the 3 cases we discussed. I would think, the application of the law would be a little bit more fair and even across the board, as opposed to having the pro-tenant decision and the pro-landlord decision.
And I think also you'd have less litigation, right?
Yeah.
If you're aware, if the law says, I'll make it very simple. If the law says you lost 50% of your business, then the rent should be abated 50%. Okay.
I think that would be the easy way to interpret it. And I think I've seen bankruptcy courts interpret it in that fashion. Senate Bill 312 requires a settlement conference in the commercial eviction proceedings. A lot of times the judges are requiring settlement conferences or, taking it upon themselves. But while in the residential context, holdovers and non-payments are required to have a settlement conference pursuant to the administrative order of the Office of Court Administration, that's not required in the commercial division. So, I think that's a good bill. I think it makes sense for people to be treated evenly across the board, even if you're in New York City, or if you're in Long Island, or if you're in upstate New York. I don't think it's incredibly burdensome to have a settlement conference. I think it'll allow orderly transition of some of these businesses that can't pay their arrears. And I think it'll prevent unnecessary litigation. So, perhaps that's something that'll get done. That's the conclusion of the prepared presentation. Did anyone on the phone or joining us via video have a question for us? We'll stick around for as long as any questions you might have.
Bobby, one question I've been getting, when I've been doing my closing things is, I know there was some legislation or some discussion, I shouldn't say legislation, some discussion of how is the city, the counties, the towns going to handle collecting real estate taxes from these landlords if they're not getting paid? And there was some discussion of, I know months ago, of maybe doing a deferment or some type of agreement with landlords if they can prove hardship. Have you heard anything beyond that or anything else?
Well, I know that my understanding is that the commercial foreclosures, I know for a fact commercial foreclosures are being stayed, and the tax foreclosures are also temporarily being stayed. But I think, to go to your broader point, the reason why we're not seeing more robust tenant-friendly protection laws being afforded to commercial tenants like you are and the residential tenants is because of that. And the state, I think, is very cognizant of the fact that there's a huge budget gap, and they need these revenues or there's going to be significant cuts in programs. And I don't think the current makeup of the legislature is going to be interested in cutting back on programs. There's going to be a day of reckoning eventually with the tax revenue that's been coming in the city and the state as a whole. And I think they're very concerned, the legislature is concerned that whatever it is they do is going to hit them in their wallets. And I think, the things that you might see done are the laws that I kind of talked about, maybe streamlining the impossibility defense, maybe requiring settlement conferences, maybe requiring mitigation of damages, but you're not going to see cancel rent. You're not going to see, perhaps you'll see an extended moratorium, but I think it would be limited, maybe to some non-payments, just to the end of the pandemic, where residential tenants, I think there'll be more flexibility, giving them time to, move on or cure the arrears. So we'll see where it goes.
So I see a question here. How important is it for a tenant to mitigate damages where there's a government shutdown? And we kind of talked about this. I think it's very important that a tenant mitigate its damages in any way that you can. If you're a dance studio, obviously you can't be 6 feet apart learning how to dance. But the dance studio could offer online sessions. Take other precautions. Now they're allowed to open up instead of having 5 lessons going on. You're allowed to have 1 lesson going on. We'll make sure you have the 1 lesson going on. I mean, anything you can do to demonstrate that you've done what you can to try to collect revenue, I think is very, very important, notwithstanding the government shutdown.
Yeah, particularly if you're in settlement conferences with the judge and you're saying, Judge, I'm doing everything I can, and I'm still not able to make ends meet. I'm giving you, 30% or 50% or whatever the case may be of the revenues. You're kind of an open book. I tend to think that the court is going to, see the equities of the situation and try to either delay the case or allow the case to move forward based on the fairness issue. Generally, the housing courts aren't courts of equity. They don't have equitable powers, but they definitely look at concepts of fairness and may take them may take that into account in their decision making. Any other questions or comments? Okay. Well, if you do have a question, something, or you're shy and you didn't want to talk about it on the webinar today, you can email me directly. That's Blink, like blink your eye, BLINK, at msgrb.com, blink@msgrb.com. Just reach out to me. We'll do a free consultation, for a landlord or for a small business that's interested in, preparing for the end of this pandemic and hopefully for 2021 and beyond, moving forward. We'll do a 20-minute consultation, and then we'll see whether or not we can help you out renegotiating the lease or helping in some other way. David, any closing thoughts?
No, that's it. Thank you, Jessica. Thank you for your comments. Judge,
Thank you.
Joel, thank you for your comments and input. Good job, Bobby.
Okay. All right. Well, thanks again. We'll hopefully speak to you guys individually. Thank you so much.
All right, take care.